You may proceed.
Your Honor, may it please the court. My name is Nick Martino, and I'm with the Office of the Public Defender and represent Mr. Darian Pease Jr. And I would request the 5 minutes for rebuttal.
Yes, sir.
Thank you. Your Honors, there are numerous issues in this case, but for organizational purposes, I'm going to deal with them in three categories. First, the ineffective assistance of counsel and the Ferretta aspect. Secondly, the individual evidentiary issues, and then if time allows, get to the cumulative argument, which I think is potentially important here. Your Honors, turning first to the ineffective assistance of counsel and the Ferretta issue. They're briefed independently because they are separate and distinct, but they also have this kind of symbiotic relationship in this case. I'd like to address first the Ferretta aspect. The trial judge actually referred to the ineffective assistance of counsel portion as one of first impression, no case law, and I would agree with that, but I think starting with the Ferretta might be a little more clear. The timeline of this case, Your Honors, from January 2019, I know the court's familiar with the facts, but I think a couple of date points are important. From January 2019 to July 1st, 2019, nothing was done on Mr. Pease's case according to this record. July 1st, his initial attorney shows up, waives his appearance improperly, doesn't inform Mr. Pease, also tells the court that Mr. Pease waived his appearance. So misrepresents that to the court. Also sets a competency hearing without even consulting with his client. It's on July 29th, one of the two initial trial judges that I'll speak about learns of this misrepresentation, waiver without cause, and then also on top of that, that Mr. Pease informs the court that he's been trying to communicate with his attorney 14 to 16 times, no responses. The trial judge at that point says, there's nothing ineffective here, we're moving forward. The other significant dates in this case, Your Honor, end up being September 26th, and then October 8th and October 14th. That September 26th date is the first time that there's ever any consideration of ineffectiveness. A new attorney has appeared at this point with the Public Defender's Office, Mr. Grant. Mr. Grant informs the court, I can't be prepared in 18 days. Now on July 29th.
And as I read it, they kind of go back and forth, Mr. Grant saying, well, if you give me an extension on Speedy, then I can be ready. And the client saying, no, I don't want the extension. And they kind of having a back and forth on that September 26th meeting.
That is correct, Your Honor, yes. And that conversation goes on between the court and Mr. Pease repeatedly throughout the transcripts, through each appearance date starting on July 29th all the way through to.
Was there ever anything definitive about how much more time Mr. Grant wanted?
Mr. Grant said that 18 days wouldn't work. That's all we know as far as what was stated.
If I could have 1 month, 2 months, 3 months, he wasn't specific about it. It was like that I could see.
He was not specific about it, Your Honor, and I think it's important to note on July 29th, that's when Mr. Grant came onto the case, and he actually made a statement on the September 26th court date that said on the 29th, he informed the initial judge that if it was going to be set for trial, he would try to get prepared. So 18 days wasn't really the timeline. Mr. Grant came on the case, and he actually would have had it for 2.5 months at that point.
So are you can't now argue that Mr. Grant was ineffective. Or are you arguing? I mean, are you arguing ineffective assistance of counsel? I didn't see that standard argued in your brief, but are you arguing Mr. Larinaga, you have a little bit of advantage because the trial court made an adjudication that he, and no offense, present company, this law firm, the Public Defender's Office, was ineffective for the purposes of this case. But for Mr. Grant, is it necessary for your argument to find that, for us to find that he too was ineffective?
He was found to be ineffective.
Mr. Grant?
The entire Public Defender's Office that took over, well, the ineffectiveness finding.
But that was by way of Mr. Larinaga.
Yes, Judge. The ineffectiveness was to the actions.
Actually, the trial court said that Mr. Grant is not effective because at the Ferretta hearing, or sorry if I'm confusing Nelson Ferretta, but he said that set up the horns of the dilemma. He said, I'm finding Mr. Grant competent, or excuse me, effective. So you have to choose to represent yourself. So how are we supposed to? Is it necessary, and how can we consider this argument if it has to be based on Mr. Grant's effectiveness?
Well, Your Honor, Mr. Grant's effectiveness never had to be considered because no facts had changed, and the court was able to go back to July 29th with Mr. Larinaga. I'm not going to get into whether Mr. Grant was ineffective or not, although I think sitting on a case for 2.5 months, knowing it was going to go to trial, may constitute that. But what this court can do is two-part. First is look to the Feretta inquiry that it was not voluntary. It potentially was knowing under that standard.
Yeah,
But
it was without a choice, it's kind of the way you said it.
Without a choice, absolutely. But the second part of it, and I think that's what you're getting to,
It
Judge.
certainly was knowing, can you see that it was knowing, and it was voluntary. I don't know how many times he was asked, he said, you have a yes or no question, you have to choose. And it was pretty knowing that the defendant seemed pretty astute to me in the record about his options and what he was giving up and what he was choosing.
I would agree it was knowingly, because that's an objective portion of that test. It was not equivocal, or it was not unequivocal, pardon me. And Your Honor, I don't believe it was voluntary. The voluntary aspect of it requires that there be some choice, and the judge here played into the improper Feretta inquiry. And I want to back up just one moment. The second part of this, where I will talk about how the ineffectiveness factors in, because I want to get to that part of it. But on the Feretta portion of it, that Feretta inquiry is supposed to take place, and it's supposed to continue to take place through every portion of the proceeding. That's not only under Feretta, but also under 3.11 D5. When Mr. Pease finally says to the judge, I seem to like Mr. Chilela here. He's doing what he should do. Can I have a continuance 5 days so we can get on board here because I want effective counsel? The judge says no. And that is actually located on the transcripts at 218, where Mr. Chilela says, listen, I need about 2 weeks, Judge. And that was originally on the October 14th. And I think that's where the ineffectiveness part factors in here, Judge Atkinson, is had the trial judge done the ineffectiveness process, the Nelson process early, when it should have been done, I would argue that any trial attorney could have tried this case. This was not an incredibly complex case. And we know that Mr. Chilela, coming in cold, said, I could do it in about 2 weeks. So that's where these two issues intersect. And I do think, even though I think Feretta is the cleaner transition here to send this back for a new trial, Your Honors, the ineffective portion part of it here, the ineffectiveness of Mr. Larinaga tainted this entire case. And the trial court's error in not dealing with that ineffectiveness until September 26th, when no other facts had changed, was a mistake on the trial court's part. And I understand the trial judge here was trying to balance a lot of things, was trying to deal with a lot of moving parts.
Let's talk about that. He's trying to balance things and ask, I mean, we're, as an appellate court, I mean, we're supposed to correct errors.
Yes.
So if the judge was presented with a situation in which there were no good options, and he or she picked this one, if he had, how is he supposed to get from P, I think, I can't remember which judge was at this point.
It's Judge Wolf.
5 cases today.
Yes.
How is he supposed to get to point A to point B? And when I asked that, let me ask a couple sub questions. One question is, if the trial court had done one of the things you said he needs to do, I don't want to use game the system pejoratively, but navigate the speed trial rule such that the trial courts respond, they would say, oh, well, you know, here's what we're going to do. And I'm going to essentially give the attorney a little time by kind of wending my way through the speedy trial rule myself. Your client would have objected. Your client would have said, Judge, no, I want to go to trial now. So how is the trial court supposed to effectuate what you think he should have done?
Well, Your Honor, I mean, there's really two answers to that. One is, assuming Mr. Pease would have objected, he would have objected, his objection would have not been taken well, and also it wouldn't have been an appellate issue at that
So
point.
you're saying that the trial court should have overruled Mr. Pease's request to go to trial as soon as possible?
Well, for sure, yes. That was one option. 3.191 specifically gives the trial court judge of their own motion the ability to initiate this process, which puts a responsibility on the trial court judge. But secondly, and I think perhaps more importantly, and this goes back to that knowing and voluntary aspect, the judge should have said to Mr. Pease, you here as a part of this waiver understand that you don't get a discharge of your case on day 175 or 180. Here's the process. When that time runs, then a motion gets filed. Then you come before the court and then it gets set. Mr. Pease seemed to understand the process pretty well. That was never explained to him. So there were two parts.
Are we presuming that that's why Mr. Pease wanted to force the speedy trial because he thought he was going to get discharged? That's not really in the record that I can see. He just was insistent on going to trial soon because he felt like it was his right and then was going to deny it.
Correct. And whatever that rationale was, I was just using discharge as an example.
But you're saying that the trial court should have, kept the defendant informed of whether what you thought he was seeking and trying to go to trial quickly would probably not have come to pass.
Yes, Your Honor, that's correct. And I think looking at Ferretta and the applicable Florida case law that interprets it, I would offer that it's relatively clear that once a trial court gets involved in that process, they have an obligation. And again, this isn't an attack on the trial court judge. It shifted from one judge to another, and the new judge came in and was dealing with a lot of these moving issues. But there were moments here where this error, and I contended as error, could have been undone. It could have been undone on July 29th. It could have been undone on September 26th. It could have been undone on October 8th. Had anybody ever asked when Mr. Grant said, I can't try this case? Well, if you can't try it, Mr. Grant, let's inquire to see if somebody else
I
can.
don't understand the first part of that premise a little better.
Yes, sir.
Is it your contention that as a matter of law, assigned defense counsel failing to take any action on a case for a period of 2 months constitutes ineffective assistance of counsel under scrutiny?
If we're talking about Mr. Grant, I don't think I can say that based on the record because it wasn't delved into. Mr. Larinaga was found to be ineffective in the PD's office. So I can't speak to that. What I can speak to is when Mr. Grant and the judge, knowing the history of this case, says, I can't try this in 18 days, the trial court should have made the ineffective assistance ruling or assessment earlier because the facts were already there.
And that goes back to kind of what I'm asking, is
Okay.
that it seems like what you're suggesting is that as a matter of law, that is ineffective assistance of counsel, period. And it is the duty of the trial court to, so in all cases and in all instances, attorneys such as the APD or Office of Regional Conflict Counsel, they have a duty to drop whatever they're doing and immediately attend to each case as it comes in real time.
If I could say yes to the first part of that explanation, no to the second part. And the Judge Wolf here agreed when he was looking at this and saying, this is a novel first impression issue because what we have is an attorney trying to waive speedy trial, which they're allowed to do, but there's no strategy behind it. It's simply based on ineffectiveness.
Well, maybe, or you could look at it as an accommodation of facts, kind of facts of life. I mean, so you could change this ever so slightly and have it where attorney was doing fine, communicating with client, taking discovery, prepping up the case, and then has, a week before trial, 2 weeks before trial, some kind of cataclysmic family event or some terrible illness such that they are completely out of the picture, can be of no assistance. And now we have basically the same scenario, right? Which is that, look, you now put me on, to use Judge Atkinson's metaphor, the horns of dilemma. I either have to take time to get a lawyer up to speed, or I've got to and fully realize my Sixth Amendment right, or I've got to waive speedy trial. It's the same issue, isn't it?
I would respectfully disagree, Judge Lucas, because 3.191 deals with these issues. It allows for exceptional circumstances. It allows for an extension by the trial court judge during expiration and during the recapture period. So the rule contemplates it for that reason. And if that attorney
But
couldn't,
the rule has no constitutional dimension to it.
yes, Your Honor, that's correct.
It is not the measure of the right to speedy trial. We all agree on that.
Agreed, Your Honor, but it gives the sitting judge the tools by which to defend that constitutional right. And I don't even think the court has to reach the constitutional issue here. I think the court can look to the idea that Ferretta can't be voluntary with all of these other mistakes that happened on behalf of his attorneys and respectfully to the trial court judge that the trial court judge made. These were errors that took away that voluntary nature of Ferretta.
Let's talk about the voluntary nature. So, and this is the rule, violation of the rule is not ipso facto violation of the Constitution. It's right now. So in order to get to, we cannot write an opinion saying he was denied his right to speedy trial, obviously, because he got it. He asked for it vehemently and he got it. So this has to be a denial of ineffective assistance of counsel for Mr. Pease to successfully establish that he's entitled to relief. So does that rely on the choice being between effective counsel and denial of the constitutional right? So in other words, would Mr. Grant's request of time, and Judge Black pointed out that we don't know how much time he needed, the record doesn't provide that, it has to have touched on it has to have risked a violation of constitutional right, not just a rule-based right.
Yes.
So let's get to that. In other words,
Yes.
you're saying under Feretta, he had no real choice.
Correct.
And so why was the simple fact that his effective lawyer, let's presume for the sake of discussion, because he was not found ineffective, his effective lawyer said, hey, I need more than 18 days. Why was that why did that risk a violation of Mr. Pease's constitutional rights?
Well, Judge, that
The answer, you are at your 5 minutes, cutting into it a little bit. Since that was a lengthy question, go ahead and I'll give you an extra minute.
Thank you, Your Honor. I appreciate that. The 18-day portion with Mr. Grant, I don't think the court looks at, because that you then have a subsequent attorney that comes in, Mr. Chilela, who says, I can do this in 2 weeks. And I think that is where the court can easily get to a resolution here.
Okay, but at that point, he said, I don't want that. I want the 2 weeks. I only want you to stand by counsel.
The day of trial, Mr. Pease asked the court, now that he had Mr. Chilela, for 5 days, and then bring the jury back and let's try this case. And the trial court judge said that would be an inconvenience on the jury without even asking. Now, I would offer that that was improper, because in addition to the requirement that there be a question at every subsequent stage of the proceeding on whether the person wants to proceed, Mr. Pease once again unequivocally said, I want an attorney. He'd been saying that throughout the process. So I think that's the simplest way to do it, Judge Atkinson.
Wish to reserve the rest of your time.
Yes, Your Honor, if I may. Thank you.
Good morning, Your Honor. May it please the court, Johnny Salgado, on behalf of the state of Florida, in this case, Mr. Pease.
Would you allow me to, in order not to sandbag you at the end to defense counsel, just to address that 5-day request, because it seems maybe to get to the nub. Could you address what defense counsel just talked about, that 5-day request, whether, in other words, we from the way I read the record, at almost every juncture, Mr. Pease said, no, I don't want any delay.
That is correct, Your Honor. He continually insisted over and over to not waive his
We'll
field
talk
trial.
about the 5 days.
Yes, in reference to that, as was mentioned, Attorney Chilela said, hey, I could do this in 2 weeks. And some dialogue went on, and he again said, no, I'm going to go forward. I want to represent myself, essentially. And that's what happened. As we stated in the brief, this is not an ineffective assistance of counsel case, because the appellant consistently chose to represent himself. Even in the Feretta case, in the Feretta opinion, and looking at that, the U.S. Supreme Court said, such a defendant may not later complain that he received ineffective assistance of counsel. So, that's our position in a nutshell. I mean, it was defendant who gave the trial court no choice but to have him represent himself. And I believe there's a Supreme Court case in Florida, Bear versus Bell, that says the defendant cannot represent himself and claim ineffective assistance of counsel. I'm available for any questions. Otherwise, we're going to just rely on our word.
I'm not quite sure. I could talk to opposing counsel. Okay.
Your Honors. So the state will rely on this brief. Thank you very much.
You have about 4 minutes left.
Judge,
Give the other judges time to talk.
I was about to say, I'd be happy to take my colleague's time. if you know. Your Honor, just if
Where
I
are we talking about, 5 days?
Oh, yes, Your Honor, the 5 days, it is on transcript 512, where the court finds that the defendant, Judge Wolf, found that Mr. Pease had adequate time to prepare, which is adding to the irony of that on October 8th, after Mr. Pease had been independent of his pro se for 2 weeks, he informed the court, Judge, I still haven't gotten my records. The PD's office hasn't produced it yet. And this is where I want to clarify the ineffective assistance of counsel. This is not an ineffective assistance of counsel case. This is a Feretta inquiry case where ineffective assistance of counsel robbed Mr. Pease of the voluntary and unequivocal nature of his proceeding pro se. And when the court looks at a statement like
So you have a right to effective assistance of counsel in a Feretta case?
No,
In a Feretta-
No, but when Feretta requires unequivocal and voluntary, and like I said, knowingly is a fairly objective standard. I'm not going to waste the court's time on that. But that's where the ineffective assistance of counsel comes in here. And that's what Judge Wolf spoke to on the record, where he said, I've never seen anything like this. Because the ineffective assistance of counsel is permeating this. In fact, he used the phrase, this is an issue of first impression. There's no case law on it. I've done pretty exhaustive searches on it. I can't find any case law on it. The state of Florida's answer brief doesn't cite any case law saying this is a novel issue. And what I'd ask your honors to do, we briefed the fundamental error portion of it, I think, in depth, and the cumulative error portion of depth. I'm not going to take the court's time with the individual evidentiary issues. We don't waive those. But I want to put a point on this by saying this is a novel issue that needs to be memorialized. This is an issue where Mr. Pease, with competent counsel, would have had a different outcome, at least on some of the counts. I think is a reasonable review of what he was charged with and the evidence. And so that's where the ineffective assistance of counsel comes in. But the state of Florida argued in their brief that, well, you can't get ineffective assistance of counsel. There's not a single scrap of precedent that says that ineffective assistance of counsel can't taint a trial when it happened pre-trial. And that's what we're dealing with here. It didn't taint the trial.
What's the remedy?
The remedy is this court finding that the Feretta inquiry could not have been unequivocal based on Mr. Pease's statement.
What was this? We're error finding for. What was the court supposed to do?
This court,
Deny him his right to represent himself.
yes, Your Honor, which the court's permitted to do. In fact, in Hill versus State, the Florida Supreme Court said that Holmes versus State, the court said in that case, trial court has to be aware of proceeding under circumstances where there's even little time to prepare on serious charges for a pro se defendant. As of October 8th, the court knew he hadn't even been provided his case file for 2 weeks. And then the Hill case, dealing with a similar issue with right to counsel and speedy trial, stated that the counsel, there has to be a lawful basis for the judge to determine that the individual can proceed pro se. Feretta is not a right. Feretta has to be screened. It has to be vetted by the trial court. This court should memorialize an opinion here that deals with what is the first impression. How did ineffective assistance of counsel factor into this choice to proceed pro se? Mr. Pease did a fairly good job objecting below, but I would offer that an attorney properly preparing this, even at the last moment, the day of trial, had the trial judge just given him a 5-day extension, he wanted to sit down with Mr. Chilela and see if Mr. Chilela could represent him. At that point, they could have moved forward and there wouldn't have been an issue on review dealing with this at least.
And you're out of time, so you're at a good stopping point.
Thank you, Your Honors.
Thank you very much.
Thank you for your time.